We've got a bombshell legal update tonight. No exaggeration. This is the kind of thing you rarely ever witness in the world of federal appellate courts. If the Second Amendment matters to you, even a little, you'll want to pay close attention. The United States Court of Appeals for the Fifth Circuit just rescinded its prior decision in United States versus Peterson. Not revised, not edited, completely wiped from the record. Legally speaking, it's like the ruling never happened at all. And that is a massive deal. So, why should this be on your radar? Because back in February, this exact court handed down one of the harshest rulings against gun rights we've seen in recent memory, declaring that suppressors, those cylindrical muzzle attachments that reduce sound signature and protect your ears, weren't covered by the Second Amendment. That verdict hit gun owners hard, especially those of us who actually use firearms in the real world. But now, that decision's been thrown out. It's officially null and void, and that changes everything. Stick around. I'm going to explain exactly how this unfolded, why it could be a turning point, and what it might mean for the future of gun rights in this country, especially if you care about suppressors, the National Firearms Act, and whether the courts are finally starting to respect the original meaning of the Constitution. If you haven't subscribed yet, now's the time. This is one you don't want to miss. Here's the quick rundown. The Peterson case centered on a man who got slapped with federal charges for owning an unregistered suppressor, something the National Firearms Act treats almost as severely as owning a full auto machine gun. If you've dealt with the NFA, you know how painful it is. Paperwork, background checks, a $200 tax stamp, and then a wait time that can drag on for over a year just to legally own what is basically a hearing protection device. But this wasn't just about jumping through bureaucratic hoops. This was about whether the Second Amendment covers suppressors at all. That was the heart of the matter. And back in February of 2025, a panel led by Judge Jennifer Elrod concluded that suppressors didn't qualify as arms under the Constitution. Why? Because they don't fire projectiles. They're not lethal on their own, and they were dismissed as accessories, not weapons. That reasoning sent shockwaves through the firearms community. Second Amendment attorneys, everyday gun owners, and even some folks inside the Justice Department were stunned. The problem? That ruling flat out ignored what the Supreme Court already said in Bruin, that the Second Amendment protects all tools commonly used for lawful self-defense. Not just the firearm, but everything that supports it. That's not a loose interpretation. It's right there in black and white. Suppressors do a lot more than reduce noise. They help with recoil management, aid in faster follow-up shots, and make defensive shooting safer for everyone nearby. Saying they're not protected by the Second Amendment? That wasn't just a misstep, it was reckless. But here's the kicker. Just a few months later, that decision has been completely vacated. It's gone. Erased. And that could reshape how courts approach the entire question of what the Constitution actually protects when it comes to firearms and accessories. The February ruling wasn't just legally weak, it ignored decades of precedent. The court's argument was that suppressors don't count as arms because they don't discharge bullets. But that's directly at odds with how the Supreme Court has defined the term in landmark decisions like District of Columbia versus Heller and New York State Rifle and Pistol Association versus Bruin. The High Court made it absolutely clear the Second Amendment covers more than just muskets and powder horns. It extends to all modern tools that aid in the act of self-defense. That includes today's rifles, handguns, and shotguns. It also includes optics, weapon-mounted lights, and yes, suppressors. That's not a fringe position. That's established constitutional doctrine. And let's talk practicality. A well-made suppressor can cut down the sound of a firearm discharge by around 20 to 30 decibels. That's not just a comfort issue. It's a health concern. A study by the National Institute for Occupational Safety and Health in 2020 showed that even a single unprotected gunshot can cause irreversible hearing damage. Suppressors help prevent that, which is exactly why they matter, not just for sport shooters, but for home defenders, hunters, and everyone in between. So where do we go from here? With the Peterson decision now pulled, the legal landscape is wide open again. This could set the stage for a major victory in recognizing suppressors as protected arms under the Constitution. And that might lead to a serious challenge to the NFA's suppressor regulations down the line. Stay tuned. We'll be watching this case closely and bringing you every development as it happens. If you believe in protecting your rights and want to hear more updates like this, make sure you're subscribed, hit that notification bell, and drop your thoughts in the comments. This might just be the biggest legal win for gun owners in 2025. Now here's where things really get interesting. The Fifth Circuit's original ruling completely overlooked how commonly suppressors are used in lawful settings across the country. As of late 2024, more than 3 million legally owned suppressors were on the books with the Bureau of Alcohol, Tobacco, Firearms, and Explosives. These are not rare or exotic tools, they're everyday equipment for hunters, sports shooters, home defenders, and yes, even law enforcement agencies. In fact, the United States Marine Corps issues suppressors to their infantry units for both battlefield effectiveness and hearing protection. If America's frontline troops are running suppressed carbines, how can any court reasonably argue that law-abiding civilians shouldn't? But the most glaring failure, the panel flat out ignored the originalist framework laid out by the Supreme Court in Bruin. Instead of applying the proper historical test, which is now the controlling legal standard, they treated suppressors like optional gear or tactical toys. That mindset doesn't just miss the mark. It undermines the entire foundation of what the Second Amendment protects. When that ruling landed back in February, it lit a fire under the pro-gun community. And for good reason. If a suppressor can be excluded from constitutional protection, what's next? Weapon lights? Red dot optics? Sling mounts? Once you start carving away exceptions, the term arms becomes subjective and meaningless. That's why the court's decision to walk it back was such a monumental shift. On June 17, 2025, without much fanfare, the Fifth Circuit issued a terse but decisive order. The prior opinion in United States v. Peterson was formally withdrawn. No legal footnotes, no partial retraction, just a clear, one-sentence reversal. And let me tell you, that's not something you see every day. In fact, it's extremely rare for a federal appellate panel to retract its own published opinion. Normally, once a decision is out, it stands unless a higher court steps in or the full bench agrees to rehear it. For the very same trio of judges to backpedal on their own, that tells you everything you need to know about how shaky their first ruling really was. So what flipped the script? One of the biggest catalysts for this reversal came straight from inside the federal government. When the original decision dropped in February, the Justice Department, still early under the incoming Trump administration, actually backed the court's narrow view. They filed a brief arguing that suppressors weren't arms under the Constitution. That move blindsided a lot of folks, especially considering the administration's stated pro-Second Amendment stance. But that didn't last long. Once John Sauer took over as Solicitor General and Harmeet Dillon stepped in to run the Civil Rights Division at the Department of Justice, the government's position did a complete 180. A new brief landed soon after, laying it out in plain terms. Suppressors are constitutionally protected. The government's argument included documented public use, safety benefits, and their adoption within military ranks. That pivot didn't just change the temperature. It likely gave the court the legal cover it needed to reverse itself without digging a deeper hole. Because at that point, it wasn't just the firearms community raising hell. The court found itself at odds with the very executive branch that had just co-signed Bruin's approach. So what does this mean going forward? We're effectively looking at a clean slate. The bad ruling is gone, the case is back on the docket, and the judges who fumbled it the first time now have a chance to get it right. That kind of second shot doesn't come often, but when it does, it shows the legal system is still capable of self-correction when enough pressure is applied. The moment that withdrawal became public, everything shifted. you could feel the momentum change across the entire gun rights community. From legal experts to grassroots advocates, the response was immediate and overwhelmingly positive. Organizations like the Firearms Policy Coalition and Gun Owners of America didn't hesitate to call it a big win, and they were right. Not just because the flawed opinion was erased, but because it signaled something bigger, a turning tide in the courts. What we're seeing now is a deeper shift in how judges across the country approach Second Amendment cases in a post-Bruen world. For years, anti-gun rulings relied on a so-called interest-balancing framework, basically saying, sure, you have rights, but the government's goals are more important. That approach is no longer on the table. Under Bruen, the burden is on the government. If they want to regulate a specific type of arm or firearm accessory, they have to prove it lines up with our historical tradition of gun laws, not modern policy goals history, period. Let's be honest, there is absolutely zero historical support for banning suppressors. The National Firearms Act wasn't enacted until the year 1934. Before that, suppressors were just another lawful shooting accessory. You could buy one at the hardware store, order one through a mail-order catalog, or walk into your local gun shop and pick one up alongside your hunting rifle. Old advertisements in sporting magazines promoted them as useful tools for target shooting, varmint control, or for anyone living near neighbors. No one treated them like sinister contraptions, they were just equipment. Trying to claim now that suppressors somehow fall outside the Second Amendment is not only factually incorrect, it's legally absurd. The Department of Justice's revised position underscores that reality. In its updated legal brief, the federal government made it clear that suppressors serve multiple legitimate purposes: protecting hearing, improving firearm control, enhancing accuracy, and supporting lawful self-defense. But they didn't stop there. They also pointed to the United States Marine Corps' landmark decision in 2020 to begin issuing suppressors across frontline infantry units. That is not some niche civilian use case. That is high-level institutional endorsement from our armed forces. Even more critically, the Justice Department acknowledged that suppressors directly improve situational awareness in high-stress defense scenarios. And that isn't just a comfort issue, it's a matter of staying alive. When someone is defending their home and family, the ability to hear movement, voices, or shouted instructions without suffering hearing loss is not a luxury, it's a necessity. So when you weigh all of this, the historical context, the constitutional foundation, and the practical benefits against the now withdrawn reasoning of the Fifth Circuit's initial ruling, the scales are not even close. The facts, the law, and the American public are all aligned in favor of freedom. And that's what makes this moment such a critical inflection point. This wasn't just a win for suppressor owners. This could be the first crack in the foundation of decades of bad case law. A reversal like this has the potential to reset the entire conversation around what kinds of arms and accessories are protected under the Second Amendment. If suppressors are back under constitutional protection, and they clearly should be then, so too are standard capacity magazines, pistol braces, and modern semi-automatic rifles. Take so-called high-capacity magazine bans as an example. States like California and New York test is whether the item is in common lawful use, and standard magazines absolutely are. They're used by millions of responsible gun owners every day for home defense, training, and competitive shooting. Apply that same logic to suppressors, and the conclusion becomes unavoidable. If suppressors are acknowledged as protected arms, then the legal justification for banning other common firearm components falls apart. And that is exactly why anti-gun groups are getting nervous. Because one course correction like this sends a loud and unmistakable message. The courts are no longer rubber-stamping unconstitutional gun control. This shift also forces us to take a hard look at the National Firearms Act itself. For nearly 100 years, the NFA has existed like it's immune from constitutional scrutiny. But it never had firm constitutional grounding. The law regulates short-barreled rifles, issue. You cannot tax a constitutional right into submission. The Supreme Court has already ruled on this principle in cases like Minneapolis Star versus Minnesota and Harper versus Virginia Board of Elections. A fundamental right cannot be conditioned on a government fee or bureaucratic delay. Some folks will say, but suppressors are still legal, you just have to go through the process. But that misses the bigger point. When the government imposes a high financial cost, months of delay, and felony penalties for noncompliance, that's not reasonable regulation. That's suppression, not just of sound, but of liberty itself. This is about far more than one case. We are witnessing the early stages of a serious legal realignment, one that doesn't just target individual regulations, but questions the entire bureaucratic framework that has quietly strangled the Second Amendment for generations. That's why this moment matters. That's why we can't afford to celebrate the win and walk away. This withdrawal wasn't the end. It was the starting shot. A retraction like this from the Fifth Circuit is incredibly rare, and it signals a willingness to correct course when constitutional errors are too big to ignore. But it's just the beginning. The cases still live. The panel will likely issue a new ruling, and there is a strong chance it could move to a full en banc review. That next opinion would set binding precedent for millions of Americans in Texas, Louisiana, and Mississippi. We cannot sit this one out. If you care about your constitutional rights, now is the time to stay involved. Read the filings, follow the docket, support the lawyers and legal groups doing the hard work in federal court. Organizations like Gun Owners of America, the Second Amendment Foundation, and the Firearms Policy Coalition are carrying the fight where it counts in the courtroom. And don't forget the legislative front. Call your members of Congress and demand support for legislation like the SHUSH Act, the bill that would remove suppressors from the National Firearms Act entirely. That proposal has been sitting in limbo for years, but with enough public pressure, it could finally move. It's time to draw the line. Our constitutional rights are not privileges. They are not permissions. They cannot be delayed, taxed, or denied. What just happened in the Fifth Circuit wasn't some technical footnote. It was a major turning point. When a federal court retracts its own opinion, that's a clear signal. They got it wrong, and now they know it. And that momentum belongs to every single American who refuses to compromise on the right to keep and bear arms. But momentum only matters if we keep pressing forward. If you believe suppressors deserve full constitutional protection, and you should, this is the moment to act. Stay loud. Stay focused. Support the groups making real progress. And above all, do not let up. Subscribe for updates. Watch the court schedule. And stand strong with the community that's pushing back against decades of creeping restrictions. The other side never rests, and neither should we. We'll see you in the next round.